Thank you everyone for attending today's presentation, Employee Fraud, the First 24 Hours. Wherever you are participating in our webinar today, we pause to acknowledge the traditional owners of the land on which we are able to continue to work. In Brisbane, we acknowledge both the Jaraga and Turrbal people and their elders past, present and emerging, and their efforts to hold the hopes, dreams, traditions and culture of Aboriginal Australia. Just some quick housekeeping before we kick off today. There we go. Just wanted to let everyone know that the webinar is being recorded. It might be easier to see the slides if you log in obviously via a desktop or laptop computer. We'd suggest closing down all other apps just to ensure the internet connection is strong. Myself and fellow presenters today will talk for around 45 minutes, and we've just left 15 minutes at the end for any questions. And obviously you can ask any questions by typing question in the Q&A, and we'll come to those at the end. But my name is Andrew Howard. I'm a partner in the Forensic Services team at BDO and have over 15 years experience specialising in fraud investigations, fraud risk assessments, litigation and data analytics. Joined by two people today. One is a fellow Forensic Services partner, Stan Gallo. Stan provides proactive risk management, investigative and technology advice to assist organisations in aligning governance, risk and compliance programs with their strategic objectives. Stan works with a range of clients across all sorts of industries, specialising in fraud, misconduct and compliance related matters, including identification, preservation and analysis of digital evidence in cyber and technology related investigations. Stan has over 30 years experience working as a detective and senior leader in law enforcement and professional services. Throughout his career, he's provided expert affidavits, testimony and acted as an appointed independent expert in a range of computer system related matters. We're also very lucky today to be joined by Judith Hishon, who is the Special Counsel at TurksLegal. Judith has over 15 years experience specialising in commercial litigation, employment and insolvency matters. Judith has acted for ASIC in conducting post-Royal Commission investigations and the Office of the Health Ombudsman in disciplinary proceedings. Judith also regularly acts for banks in relation to security enforcements and insolvency matters. Today, we decided to run this webinar as between the three of us, we've investigated hundreds of fraud investigations. And what we commonly see is what happens in the first 24 hours can have a major impact on the investigation and any potential success of civil recoveries, which is obviously quite important, getting money back into a business if fraud has occurred. So we wanted to share our thoughts and insights today to help people, I guess, firstly, mitigate the fallout from employee fraud, while also helping businesses try and recover as quickly as possible. So as I mentioned at the start, the first 24 hours of an investigation, in our opinion, can really make or break the overall investigation. We'll touch on a number of recent case studies while we go throughout today's presentation, but I think with any investigation, we would normally try and break it down into 5 main stages. So stage 1 is around establishing privilege at the start of an investigation, right through to stage 5 recovery and moving forward. But I guess before we get into today's presentation, I just wanted to pause for a minute just to, I guess, quickly talk about how big the problem of fraud is. In the recent ACFE report to the nations, the 2020 global survey, they did a survey across 125 countries, 2,500 cases of fraud were surveyed, equating to about 3.6 billion in losses, with the average fraud being 1.5 million. I know from personal experience that a lot of the fraud investigations we're involved with now, it's very, very common for them to be in excess of $1 million, sometimes as high as $2, $3, $4, $5, $6 million. So it's not uncommon that a potential client might come to us thinking that their exposure might be 20 or 30K, and by the time we finish the investigation, unfortunately, we're into the millions. A couple of other key points, I think, from the recent survey. I mean, hindsight's always a wonderful thing, and looking back, you'll always see potential red flags that perhaps weren't acted on or may have been ignored at the time. But 40% of the frauds were, I guess, linked to people living beyond their means, and 26% of the frauds were linked to people that were experiencing financial difficulties. So I guess that is something worth just keeping in the back of your mind, particularly as the financial pressures of COVID continue to kind of bite down. Some other kind of interesting points, I think, there, and this is probably some stuff that Stan will touch on later, but a lot of, I think, people, when they think of fraud, traditionally think, money gets moved from one account to the other, which is correct. But with any fraud that occurs, the fraudster's then got to hide it, or try and bury the transaction, or create some false documentation to support the transaction. So what the recent ACFE survey found that 36% of frauds resulted in a physical alteration of documents, but I think more surprisingly, or perhaps not surprisingly, Stan, 27% of fraud cases resulted in electronic documentations being altered, or the creation of fraudulent electronic documentations. And again, I know just from personal experience of matters we worked on in the past, it's not uncommon for fraudsters to generate, fake electronic invoices and those sorts of things to try and support or help kind of hide the money that they've embezzled. Probably the biggest number that sticks out for me on that slide is that it's kind of estimated that 5% of organisational revenues each year is lost to fraud. So, that can add up very, very quickly. So again, the ACFE are kind of estimating that it could be as high as 4.5 trillion each year is lost in fraud. So I said, just kind of wanted to set the scene of how big the problem is. In my 15 plus years experience working at BDO, particularly in the forensic space, we've always had kind of multiple fraud investigations on at any one time. So unfortunately, it's very, very common. But as I said at the start, there's probably 5 main stages we wanted to run through today. So I might just pass over to Judith, who will kind of run us through stage 1 around the importance of establishing privilege and why we need it before we kind of kick off any fraud investigation.
Thanks, Andrew, and good afternoon. So for anyone who's had anything to do with legal professional privilege, you'll know that it can be an interesting journey. For today's purposes, I'll simplify a lot of the concepts for the sake of time. So firstly, looking at what privilege is. So legal professional privilege is a protection. It's afforded to certain confidential communications and documents. And whilst it is called legal professional privilege, the privilege actually rests with the client of the lawyer. So in the types of scenarios we'll be addressing today, I'm looking at 2 different types of privilege, being advice privilege and litigation privilege. So engaging lawyers alone and just sending documents to lawyers alone is not sufficient to attract the privilege. Each communication or document will be assessed individually to see if the privilege applies. And the purpose of the communication or the document is key. So in simple terms, if a confidential communication takes place between a lawyer and their client, and the dominant purpose of that communication is to obtain legal advice, then that communication or document or advice will be privileged. Separately, if you engage lawyers and create documents which are designed to address foreshadowed or anticipated proceedings, those documents will also attach the privilege. So the importance of privilege is the next issue we look at. As part of the investigation, there will be confidential communications that you will want to protect, I expect, from third parties. For example, there could be confidential information about the operation of your organisation, which could be commercially sensitive. The financial position of your company and parts of it may also be something that you don't necessarily want to be producing to third parties. And also the identification of informants or witnesses within the organisation who wish to assist but can remain unidentified for the purposes of litigation. So not all documents or communications will remain privileged with respect to reports once they get filed in the court, and each jurisdiction has its own laws about that, which are quite detailed. So privilege is also something that is very easily waived by a client or by another party. Even referring to the existence of particular legal advice can waive the privilege in it. So the bonus of engaging lawyers and keeping lawyers engaged as part of this process is that we can help you maintain that privilege and give you guidance about how not to waive that privilege. Of course, you can engage Andrew or Stan directly without going through lawyers. But in our view, the combination of skills that we bring and the communication privilege and that you obtain at the outset dealing with us will assist the matter in moving not only swiftly, but more carefully.
Probably particularly at the back end of the investigation as well, which we'll touch on a little bit later. One of the things that happens quite often is we'll get a call and a client may suspect that fraud's occurring, or they'll want to jump straight into, I guess, kind of perhaps putting people on leave or terminating their employment. One of the, I guess, key stages is really for us stage 2, and the first part is really triaging the situation, and I guess it's a step that's overlooked quite a lot. So again, I'll kind of defer to Stan and Judith here, but probably for me, this is one of the key points out of today is really, if you do suspect something has gone on and privilege has been established, really the next step, and probably the most important step, is really triaging the situation before we go forward. But Stan, I think one for you here, whether we do a covert or overt investigation, and what is the difference?
Yeah, thanks, Andrew. I think looking at this list around the triage generally underscores the point about the different capabilities of the people. So as Judith just mentioned in relation to the privilege issue, the different skill sets, you can see that this entire list here is combined of capability that might be with me, or some of it in a legal context, some of it in an accounting context. So it's important, I think, to just note as a whole, the answering these questions will require advice from a range of people with a range of skill sets. Initially considering covert versus overt, each individual matter has to be considered on its own merits. So generally, when we come across this question, it's a matter of timing versus considerations like loss of evidence. If it's something that needs to be reacted to immediately, then overt is going to be the way to go, and you can do seizures of equipment and phones and things if there's a potential for immediate loss of evidence, given particularly with electronic evidence, the volatile nature of it. It exists 1 minute and can be deleted the next, and deleted data might be recoverable, but of course it can be securely deleted as well. Or the nature of the matter may be that you need to have initial action, like preventing an international bank transfer or something like that from proceeding. So in that case, you would go overt. Covert might be in an initial triage process where you're considering what the ramifications are if there's an opportunity to preserve evidence before people become aware of the discovery of the fraud. In this case, then you're able to take steps to proactively preserve that information before or as part of the triage process. So that will help you identify exactly what is the nature, because you can't preempt those decisions about this is a fraud and this person's done the wrong thing. So it's important to gather that initial material and then consider in light of the other questions and the broader circumstances, so that you're not improperly making allegations or whatever it may be, or taking the incorrect action initially without the benefit of all the information that you have. Often it's a decision that has to be made very quickly, particularly if there is, as I say, an urgent need to preserve evidence. But that will, each of these questions provide part of an answer to an overall whole in terms of the triage process, such as dealing with the suspect, for example.
Yes, and I think these situations almost invariably involve a lot of emotions, particularly whilst they might still be large companies that run, like a family company, and keeping a cool head is really important. And sometimes having experts around you can help you to do that, because the key word in that bullet point is suspect. So whilst it may seem undeniable from your point of view that the relevant suspect is guilty, they're not guilty until they're convicted by a court. I would hate to see an employer act capriciously and lose some of its rights by not protecting its own position. Mm. So, and as far as legal positions go, I think the element of surprise just can't be underestimated. And we've had a situation, Andrew and I, on a matter where we had to permit, or our client had to permit an employee to continue in a role where they were no doubt continuing to commit fraud. But it was important that we gathered evidence and could take appropriate steps to deal with that suspect in the short interim to preserve evidence, as Stan, of course, has referred to.
Interestingly enough, when you're dealing with the suspect, it can go the other way. So where the person is committing fraud, for example, but the employer, fraud is a breach of trust by nature, right? So the employer feels that, this person that's worked with them for a long time is known, has been home and met their family or whatever it may be. The employer finds it very difficult to accept that this is something that can be explained, and they go ahead and talk to the person about it, and then you have the subsequent actions of the person to remove evidence or take actions against that, and it can put the employer at a disadvantage because those emotions that you mentioned, Judith, come into it where this can't possibly be right, and there's an overwhelming sense of, or a desire to talk to the person about it and say, well, what's going on? Are you, is there a gambling problem, or have you got some sort of relationship breakdown or whatever that's driving this? And they want to go and talk to it, and all of the other issues about evidence preservation, all that, without the proper advice, tends to fall to the side, but then they're very difficult to pick up later on when it all sort of bubbles to the surface that, yes, it really did happen and the person is not who they appeared to be in that sense.
Mm. Absolutely.
And I think avoiding potential unfair dismissal claims is something worth keeping in mind, and again, getting some advice from someone like Judith around that. I can recall a case a couple of years ago now where we were told that 2 people have been stood down for committing fraud. We were asked to come and investigate. Now, that second bullet point there, how do we deal with suspect or suspects? In the matter I was just talking about, 2 people were stood down, but only one person, I guess, was guilty of the fraud. The other person was essentially just guilty by association because they'd occasionally have lunch with this person. So the second person did put an unfair dismissal claim against the organisation, which I think in the end caused them more headaches than the actual fraud in the first instance. Yeah. Judith, I might ask you again around the potential need for an internal or external communication plan, and I guess the advantages of, again, being on the front foot with something like that.
Yes, there are a lot of issues to consider, particularly avoiding, obviously when you're in the covert situation, we'll keep communications to a minimum, but once the suspect is being dealt with from an employment point of view, I think it's really important to very openly and sensibly deal with the employees who have had dealings with that suspect as part of their role, partly to direct them not to communicate further with the suspect, because we have had situations where the suspect is stood down or terminated and then attempts to make contact with people in accounts or people in other departments that can that may not be aware of what's gone on, and will give them access to things that they really shouldn't have access to. So there should be a meeting of some description and probably a carefully worded memo to ensure that, again, we're not saying that this person is guilty of anything because they remain a suspect, but a direction that you're not to be dealing with that person.
I think there's also a need there with staff because they are impacted, particularly if they're in the same team or know the employee well, that the impact of the issue on them. So firstly, their first thought might be, are they also a suspect now, even though they haven't done anything wrong because they work closely with this person, or why didn't they see it, or there's a guilt on, I knew that he liked to punt, or that she had a problem with alcohol or whatever it was, but I didn't think it was this, and now I know, I feel guilty. And we often see that other members who haven't done anything wrong but have worked closely with a person who's subsequently convicted or ejected from the organisation tend to leave anyway, because they feel personally there's a trust betrayal by this person to them, but also there's that air of suspicion, does the firm believe that I had something to do with this, or so that the communication needs to think about how that messaging can be put to them as well.
Mm-hmm.
Agreed. And also subject to the nature of the employer's business, I would always recommend to have some sort of statement ready for any inquiries made by the press, because sometimes people like to live out their dramas on social media or in other ways. And it's awkward when a receptionist receives a call from a member of the press and doesn't know what to say. So we can assist with drafting appropriate comments in that regard.
And what about insurance? Will that cover me if I've been subject to a fraud?
Potentially, yes. Fidelity insurance is the usual type of insurance that is responsive to that type of event. There are some types of business interruption insurance which also might respond. And we can certainly look at your policies and we can deal with insurers. And sometimes it helps when you have lawyers dealing with insurers, they are very responsive. Also, I think notification really should be made as soon as possible. A lot of policies certainly require notification as early as possible. However, notification also has to be balanced with any covert activity. So I usually advise for notification to happen immediately after termination of the suspect's employment.
Mm-hmm. Excellent. So I've established privilege. I'm either doing a covert or overt investigation. I've dealt with the suspect or suspects. Stan, when should I get the police involved?
That's an interesting question. I get this one a lot. So coming from a law enforcement background, there's the focus, the police are collaborative, let me say that up front, but the focus is quite different. Theirs is, there's an allegation that of a crime that they have to investigate, and they do that. So they go down that route. The secondary considerations, such as the business or the communications or the public image and reputation, all of that is secondary, because that's not their focus or their area of focus. With that, there's been any number of jobs in my consulting career where we've engaged very effectively with law enforcement, because they have certain powers that we as civilians certainly don't have, and they can fast track a lot. In other instances, so a typical fraud, for example, the investigation process, there's for those who aren't aware, there's for fraud within Queensland, there's a an initial triage period within law enforcement, and then they decide whether it's going to be actively investigated by fraud and corporate crime or pushed out to local regional CIB. They have other priorities as well. So, injuries, assaults, murders, child-related offences, whatever else. So they prioritise on that basis. And they will move that around, and that process takes time. And given our earlier comments around preservation of electronic evidence or the volatility of that evidence, that can be a hindrance rather than a help. Conversely, they have access to things such as bank statements and things where they can order those things and get them and save an entire court process if necessary. So working with them is important. When do you call them? The police they're a government resourced organisation, and they have to balance those resources accordingly, and they do their best to do that. With that, anyone who's been involved in a fraud investigation will know that the criminal side of it can take a number of years to go from beginning to end, and some of that's the court process, etc. So the best alignment is to advise them. So initially, I would go through the triage process, understand what you have. The police are more likely to respond the way you would expect them to if you can present a clear-cut case. If that happens to include preserved evidence, there's details of the allegations and activity, there's other information that you pulled together as a result of that process, put a bow around it and hand it to them, then they can see that it is all laid out. They're not typically experts in accounting or technology or other areas, but they do have access to those people, albeit there's priorities to deal with. So when to call them will depend on the matter. It's not effective to lock them out until the end, because you'll find that you've got to go the long way around to do a lot of things. Again, if you call them straight off the bat, because essentially the police do it for nothing and there's no cost to you, but their priorities are different. So you may find that the investigation takes a path that's not aligned with your requirements in the organisation purely because they have a job to do. The better prepared you are for when you provide and make the complaint or the report to the police, the better result you will get. So it's a balance of all of those details. Also, it's useful to have those established relationships from either a prior history like I have, or with the ongoing consulting work, so you know who to call in the police, as opposed to just pick up the phone and ring headquarters and hope that you get put onto the right person. Fraud investigation is just like any other specialist area. So knowing and having those relationships, if it is pushed out to local CIB, then what does that mean for a fraud investigation where you might need accounting expertise or something like that? Policing is moving to a more collaborative approach in a whole range of areas. Fraud is one of those, and they certainly recognise the value of preservation of electronic evidence as an example, or having an expert who's able to provide testimony around how a file was modified, an invoice or whatever it may be.
And they can help if we think a suspect might be at risk of fleeing the country?
Yeah, look, this reminds me of a particular matter where, and as I mentioned before, in this case, there was a gambling addiction. It was a team of 4. The person stole $1.2 million from a non-profit organisation. The employer felt so bad that they spoke to the employee, the fraudster, and talked to them about their issue. The other staff had seen him on the gambling websites, and he kind of shrunk that when they came by. 3 of the 4 had left within a year. 3 of the 4 staff had left within a year. The 4th one was the baddie. He told the employer that he needed to go home. They went overt. He needed to go home and think about it, and he was upset. So the employer, feeling bad for him, said yes. He drove straight to the airport, bought a ticket, and took off to Colombo, where he had family. So then there was this long process of reaching out to Colombo. So the law enforcement were able to tell us that he'd gone. But there's a fraud in itself. There's a whole process to try and get that person back, and whether it's justified use of their resources in order to do that. In that particular case, multi-jurisdictional issues become very complex, so you've got to look at that. we as a global organisation were able to reach out to a Colombo office and have someone go around and say hello and convince him to return, which ultimately he voluntarily returned to Australia and showed up at the watch house, the police watch house, with a suitcase, which was interesting. And he did some time over that, but he did voluntarily return. But had he chosen to stay there, it would have been very difficult to go through the whole extradition process. So certainly the suspect in that case took the opportunity to flee, and others do too. It depends on who they are and where their family is, and are they native Australian or not, and that kind of thing. So there is some considerations, but certainly it is a risk, and if it happens, it's very difficult to operate in a reactive sense.
Maybe another reason to get the police involved sooner rather than later.
They can lock down if it's the type of offence. They can lock down border changes. Of course, in COVID, nobody's going anywhere anyway, but you can lock down ports, airports, trap those sorts of people anyway, and prevent them if they're trying to flee. And the police can do that with a couple of calls. So that's certainly a benefit of having them involved.
Before we move on to potential freezing orders, something that quite often is overlooked is really sometimes the simple things. So like changing physical locks, bank signatories, and IT access, even remote access as well. So if it's one thing to stand someone down, but if they've still got keys and they can unlock and come into a business after hours, again, there's that risk of evidence being destroyed, or dialing in remotely and deleting accounting evidence are all kind of risks that we want to kind of avoid. But I think Judith, if we've got a suspect, we're doing a covert investigation, we've identified that this person or persons potentially have a large asset pool, what can be done?
Thanks, Andrew. There certainly seems to be an interesting trend in recent times for fraudsters to actually create assets out of their stolen funds rather than just dissipate it in what I call the old-fashioned way. So it's quite helpful. So we can help with establishing what assets might be available, and often we recommend obtaining a freezing order. So the way that you do that is commencing civil proceedings, and you make what's called an ex parte application. So we make it without notice to the fraudster. And a freezing order is fairly much what it sounds like. It freezes the assets of the defendant, whether you can identify them or not, whether they're in Australia or overseas, and usually up to the value of the amount of the fraud or the estimated amount of the fraud. So that is where the fabulous forensic reports that are completed by Andrew and reports completed by Stan are very helpful to the court, because we front up to a judge who is handed a lot of evidence and needs to make a very quick decision about whether he will freeze the assets or not. So we'll discuss the details of how to get those and who's eligible and how they work shortly. But they have proven in the past to be a very effective tool for getting back real money.
As you said, I think there has been a trend for fraudsters to divert money to asset pools. Some of the, again, recent matters we worked on, there's been large property pools, asset pools, fast cars, expensive handbags, lots of things that potentially someone like yourself, Judith, can come in, put a freezing order on, and we can try and get some civil recovery back into the organisation, and more importantly, funds back into the business. After we've triaged the situation, obviously securing evidence is very important, and I'm just a bit mindful of time there, but I think probably the key takeaway there is that while it is a fraud investigation, the potential evidence is a lot more than just the accounting evidence. So, gone are the days where we're just looking at bank statements. It's, I guess, leveraging off people like Stan and forensic technology. So, what emails are there? What are people being messaging on their mobile phones or messaging apps? CCTV is another one that's quite often overlooked. Someone like Judith coming in, and I think Stan touched on it before, potential witness statements. What are other people seeing, doing, hearing? those sorts of things. And I think too, more importantly, is I guess the need to ensure that the rules of evidence are followed. Stan, I might just get you to maybe quickly touch on that before we continue.
Particularly, so if hard copy evidence is gone, it's gone, and soft copy is volatile and may be recoverable, but how do you present that in a legal proceeding, whether it's civil or criminal, and make sure that it's not been modified, that sort of thing. So it has to be admissible. So the entire process of preservation, handling of evidence, analysis of that evidence, and then presentation of it to a proceedings has to be within the legal guidelines for doing so. And by its very nature, if you're recovering a deleted file, for example, and then trying to present that, well, how do you present something to, whether it be a court judge or a tribunal, something that doesn't exist in the real world and never has, and then talk about how it was modified and changed. And just on the electronic evidence point, it is important to think, so CCTV one is one that commonly is missed, but also things like swiping in and out of the building when you tap your card on the lift or the door. And we live in a world now where everything's connected. So all of that contains potential evidence. People tend to think laptop, phone, email straight away, and then that's it. But with IoT, Internet of Things, everything that connects or collects information about people's whereabouts, movements, activities is all potential supportive evidence. So all of those things need to be considered in light of the rules of collection, analysis, and presentation.
Yep. So once we've triaged, I guess we move into stage 3, which is essentially the investigation. Again, from past experience, this is normally, from our point of view, kind of completed on 3 fronts in parallel. So we've got, I guess, the forensic accounting side of things, the forensic technology side of things, and then also Judith and the legal team running their side of things. And Judith will talk more about civil and criminal proceedings a little bit later. I guess for us, the key thing to always remember is that the investigation should always be completed to a court standard. So Judith, you might be able to kind of elaborate a little bit on more what that means and I guess the standards that are needed if we want to present something in court, particularly if freezing orders are required.
Yeah, so I think if you haven't had the experience of running through one of these investigations and all the way through to the end, I didn't appreciate before I did the first one that how important the forensic report that is generated at the beginning really is. So we use it to obtain the freezing orders. Then, of course, we give it to the police, who then use it to fast track, in my experience, pursuing him or her in the criminal proceedings. And then it's used again then by the DPP if there's a prosecution. So it really is incredibly important that when the evidence is compiled and the report's made, that it be just unable to be challenged and be as clear and concise and have all the information that a layperson needs to understand exactly what's going on.
And so if we're going to, if we've established that the suspect has an asset pool and we want to get some freezing orders, in your experience, how do we go about this and what evidence would be required, particularly if we're only part way through an investigation and I guess we haven't got that luxury of waiting for weeks or months?
Yes, so in order to apply, you have to have a draft pleading available, which sets out the relief that you would seek against the defendant in the civil proceedings. And that is relevant because you have to satisfy the threshold issue that the employer has a good arguable case. Secondly, you need to have sufficient proof of the alleged fraud. So if we don't have the benefit of a completed report, we may have a smaller version of the report or information from an expert explaining what's going on to the extent we can understand it at the relevant time. And that satisfies a number of issues that need to be addressed, including the fact that you really have to have a reasonable suspicion that the suspect may dispose of assets, diminish their value, or or flee the jurisdiction. So to establish that the assets are at risk can sometimes be quite difficult, but when you have evidence of fraud, the court often accepts the fact that they've already potentially committed a fraud means that they have the potential to dispose of the assets. So that deals with two things, which is good. And then we need to identify the assets that we can owned by the suspect. And often I can deal with things like real property, motor vehicles, and anything else that's recorded on a register. But the employer will often have access to bank accounts by virtue of where payments for wages are sent. And they will have other information because they work with this person. Does he have a boat? Does he talk about his holiday house? That type of thing. And then probably one of the harder things for applicants is that they must provide an undertaking as to damages. And that has to be done in an affidavit by an appropriate officer of the employer. So you also have to set out that you have the financial resources to satisfy that undertaking, or you have to provide security. Now that's because it's essentially an injunction against the world. So it's really just to address the potential damage to anyone who's adversely affected by the orders. Mm-hmm. And of course, initially the orders are only for 2 to 3 business days, usually for enough time to serve them on the defendant, and then we all go back before court, and they're usually further extended. The trick that I have learnt over my years of applying for freezing orders is that before I go to apply for the freezing order, I make sure that I have a very comprehensive list of every deposit-taking institution in Australia and every other entity that might in any way hold any assets, because if they're not on notice, they can't comply with the order. And there are some horror stories of people forgetting, just going to the banks and forgetting building societies or forgetting smaller institutions that may hold assets.
Mm. So I guess I've done my investigation. I've got a freezing order. I've engaged law enforcement who have put a stop on the, I guess, the suspect's passports. I know they're not going to flee the country. My experts have all been engaged. And so I guess I'm at that pointy end of now terminating the suspect's employment. Can I fire them, Judith?
Well, fraud is serious misconduct and usually can certainly be used as a tool for immediate dismissal. But again, a suspect not convicted, and if your information is in any way potentially not accurate, you do need to be careful. So I always recommend that you have a suitably qualified lawyer attend the termination meeting, if not conduct the termination meeting. As a very rough guideline, there really needs to be a formal meeting. There needs to be an opportunity for the suspect to have a support person at the meeting. There needs to be, you need to discuss the allegations and explain to the suspect exactly why they're being dismissed. You need to give them an opportunity to respond if they wish to. In my experience, they don't often wish to. And you should inform them as to how you're going to deal with the allegations. So these are the next steps that we're going to take, that type of information. And also lawyers can then assist with how you deal with surrender of items, cloning of phones, supervising he or she when they collect their essential items, documenting what else is in their office. Andrew and I have had the experience where after someone has been terminated, we've located a stash of very valuable items in their office. But really we need to be very careful about not breaching any of their rights under the Australian workplace laws.
I think that's a good point. As you said, they're still a suspect. I think stage 4, this is probably, again, I think a lot of people may have heard about a criminal process or the civil process, but obviously they're two separate proceedings that again can run kind of in parallel. Stan, I might kind of defer to you quickly first on the criminal side. What is it? What can we expect to happen? We've got our expert report. Judith has stood the suspect down. We've ticked all the boxes there. We've got our brief of evidence in a nice big ribbon and bow. We've handed it to the law enforcement who've engaged very early in the piece. From my experience watching CSI Miami and CSI New York, it all gets wrapped up in the next 10 minutes. But
excluding ads.
Excluding ads. But in reality, what can I expect?
Look, as soon as the police are more likely to act, as I mentioned before, in the way that you would expect if you give them the tools for that. Once they've charged the person, it goes into the criminal process, and that's a lot of the time the police are on the receiving end of calls that it's been a week and why has nothing happened, but the court process takes over at that place. So if the important part is having a brief that is solid in terms of evidence, in terms of evidentiary process, in terms of reports and expert reports, etc. So they have all of the evidence enough to make a decision to charge the person and then proceed with that. So depending on the nature of it, it can go through a magistrate's court, it can go up to district or indeed Supreme, depending on the nature of the issues. Then there's the suspect's rights to either plead guilty and admit it or fight the allegations, in which can, of course, the police have to prepare a full brief, and if you've already done that, that saves a lot of time. But it can also assist the suspect in making a decision as to whether they want to fight the charges or not, because they get to see a copy of the evidence that's against them. Mm-hmm. So that can all shorten the process. It can drag out depending on the complexity and the nature of it, and if they're fighting it, for example, it can drag out over a period of years. If everything is done properly and all of the evidence is collected, there's no issues or none of that other lost evidence that Judith mentioned earlier, and things are done appropriately from the word go, it can dramatically shorten that time frame, including a guilty plea if that's the way it goes. Mm-hmm. Will the person end up in court? Well, that depends on their role in the instance, and I'm not talking about the baddie here, but the client or our clients or the experts will provide evidence and testimony if they've done their role, and it is important to understand that, because there are some companies that do excellent work, but they just do not provide legal testimony or expert services because they don't follow that evidentiary process for reasons around, they need to do their job, and that may clash with the evidentiary process. So it's important to understand that when you do that. So ultimately, will they end up in court on the front page of the paper? That can be somewhat out of your control. So you need to have that communication plan. If that's the case and the matter does go in front of the paper, that earlier plan that Judith mentioned comes into play again there. If they're required to go to court, then yes. But if you've done the brief properly, you'll know in advance if there is a not guilty plea and the matter's set down for a trial or a hearing, then you'll know whether you're a witness or not, and you'll be appropriately prepared for that. If it's the shortcut version and they look at the weight of evidence against them and go, there's no way I'm getting away with this, they plead, then you're not going to, but you could still end up on the paper. So the comms plan is particularly important. Mm.
And then Judith, what about the civil side? So we've handed over to the DPP or the police, the criminal side's underway. We know that the suspect has got the real property. What can I do to perhaps start going about recovering some of those assets and getting money back into my business?
Well, initially there's a delay. So in Queensland in particular, you have a right against self-incrimination. So often the civil proceedings will grind to a halt while the criminal proceedings are on. The freezing order will remain in place and the assets will be protected, but usually they cannot defend the civil proceedings or provide affidavits or do any of the normal things you would do because they will incriminate themselves. So often I find that shuts down for a little while and then that's re-enlivened once the criminal matter is dealt with. Mm. However, sometimes the DPP determines there isn't sufficient evidence, or even the police determine there isn't sufficient evidence, and that can certainly happen. I had a matter many years ago in Melbourne that went for 4 years trying to recover $2.4 million that had been stolen from one sister, from another sister in another jurisdiction, and the police were never involved in that. And that only went for so long because it was fully defended. There was a trial and it was very complex. but usually I find if they are found guilty or plead guilty, which does happen, the civil proceedings then ramp back up and can usually be pretty easily dealt with. Just a matter of realising assets and getting the appropriate orders.
Probably highlights again the need to make sure that when you do go to the police, if you do have those experts involved early, they can pull the brief of evidence together, wrap it up, and I guess help expedite the police. Because as you said, Stan, they are kind of under-resourced. Stage 5, just quickly before we move into a case study and then some questions from everyone. It's probably, I think, a stage in my experience that a lot of clients that we have helped through fraud matters, they kind of tend to, I think, want to skip this stage. But again, it's quite important. Obviously, we want to kind of round out any insurance or civil claims. Also, our internal and external communication. So whether that's getting on the front foot and actually releasing a statement externally. But probably a couple of key things there is how did the fraud occur and any lessons learned from it. Again, our experience is that clients kind of want to sometimes gloss over this, but it's quite important, particularly around, well, then how do we mitigate the risk of future frauds from not occurring? And, you know, again, I've got a real life example where we called in to do a fraud investigation. Unfortunately, it was a bit like, I think your example before, Judith. It was a family matter. So it was 2 family members committing the fraud. That was dealt with by the police. New people were brought in into the finance area to replace the family members that had gone, and then 6 months later they started committing fraud. So this organisation, unfortunately, I think kind of skipped bullet points 3 and 4 there. Didn't kind of want to learn from any lessons learned, and the same control weaknesses, I guess, that were taken advantage of in the first time were still there moving forward. And unfortunately, I think that is, they say you never get struck twice by lightning, but very unlucky that they were kind of subject to a second fraud. But off the back of that as well, and I guess learning and moving forward, I think, Judith, is there anything else that we can do there around perhaps background checks, updating employment contracts, or any other policies or procedures?
Certainly, and I'll be quite brief due to time constraints, but essentially I would always get a background check for an employee who's going to have access to funds, particularly to the decision about where funds are placed. There are limitations on background checks, which Stan can certainly discuss, where you won't necessarily get everything, but you will only get probably criminal convictions that relate to the type of employment that person is entering, and that is probably sufficient for most people's purposes. I think employment contracts, overt monitoring, it should be well set out and well documented in employment contracts. Also, I think having a fraud policy is extremely valuable. It raises awareness amongst your staff. It ensures the staff understands exactly what the company considers to be fraud and considers to be unacceptable. It also might help them to recognise fraud, because I think sometimes, as Stan mentioned earlier, employees doubt themselves and question their own sort of with a retrospective view of what they could have done or seen, and certainly it puts them on alert to certain things. And also the policy can set out exactly what steps the company will take, so it's clear to everyone. Of course, with the overt monitoring as well, and what I like to call surveillance, you just need to be really careful about the Privacy Act, of course, at a Commonwealth level, and certain states have legislation designed to also protect privacy. So those things all need to be addressed.
So Stan, if I do a background check, will that bring up all my skeletons, or
not necessarily, but I mean they're valuable, and you should be aware of the limitations of them. But also consider in mind your own capability. We've had a number of instances where a quick Google search has identified all sorts of things about people that may not be caught up or have been identified in the employment process. So be aware of what you can do in that space and the limitations of that too. Make sure you got the right person, for example. You know, not even a Stan Gallo name is, there's 2 of us in Queensland. So be aware that you're not looking at the wrong person, but those checks are available.
I believe everything I read on Google, so it's all good. And before we get into some questions, we just want to kind of run you through, again, kind of a recent case study, and we've broken it down into the various stages that we've kind of talked about today, plus the various, I guess, accounting, legal, and FTech perspectives throughout the investigation. But you know, I received a call from a client. I think it might have been on a Thursday or a Wednesday afternoon. It was quite late. You know, immediately had Judith involved, and I guess privilege initially was just established for completeness, and it was I guess at this stage because we didn't know what we didn't know, so it was established just in case. Covert investigation commenced, so that was so we could secure evidence. The FTech team, so they were again covertly kind of logging in, cloning the suspect's email account without them even knowing at the time. Again, we're able to get the police kind of involved very early in the piece, mainly to put a stop on the suspect's passport. So I think, Stan, from memory, that covers airports and ports.
Indeed. Yep.
So at least we knew they couldn't leave the country. Back then, the Queensland and New South Wales borders were still open, so we couldn't stop that. But we knew they'll be at least somewhere in Australia. What the investigations identified was that, excuse me, that the suspect had a significant property portfolio. We essentially traced about $2.5 million from the organisation to the suspect's bank account. They weren't overly, I guess, smart. We were able to recover emails and internet history where they'd initially set up this bank account, which I think, from memory, was quite key, particularly in gaining the freezing orders. So we could clearly demonstrate that the 2.5 was going to a bank account that, again, had been kind of set up by the suspect and was under the suspect's control. This was over a 3-week period. The client, although they wanted to, I guess, fire this person on the spot, I guess just initially triaging that situation, identifying what they had, getting the freezing orders, really, I guess, helped the back end where the client was able to kind of gain some sort of civil recovery through those properties. But all the, I guess, the ducks were lined up, so to speak. Once all that was done, the suspect was called to a meeting where obviously their employment was terminated. We'd been working very closely with law enforcement. They were there on the same day. So I think within half an hour of being terminated, they were then charged for fraud. So probably not the best day for them. And then immediately an internal and external communication plan was implemented. So at that stage, it was mainly the internal communication plan that was of importance. So as Judith mentioned before, you know, we wanted to kind of mitigate the suspect ringing up staff members, you know, trying to twist stories, you know, potentially destroying evidence and all those sorts of things. The civil and criminal proceedings both commenced almost immediately. The DPP obviously took charge of the criminal action. Thankfully, the suspect then turned very quickly into the perpetrator. They took an early plea, which avoided a court trial, but I think, Stan, it might also means it reduces their any potential sentencing.
Possibly.
Which then kind of helped expedite the civil proceedings as well. So once all that was done, we essentially then moved into, I guess, stage 5, which was the recovery and moving forward. So again, the client got on the front foot. They then actually released an external statement to the paper. So again, to mitigate the paper finding out or the paper ringing someone within the organisation, they took the lead on that, released a statement which I guess put everything to bed. They then undertook a fraud risk assessment to help reduce the risk of fraud occurring again. They set up new whistleblower policy and procedures with the help of Judith and her team. And then civil recovery was received initially on one front, being fidelity insurance, and then it continued with the recovery thereafter of some of the real property. But we thought that was kind of a good snapshot to show you, I guess, an investigation start to finish, and how we move through each stage, and again, how FTech, accounting and legal kind of come together. But I think we've got 1 or 2 questions here. Let's have a quick look. Okay. So we've got one here. How long can a covert observation last? Days, months, years? I think Stan or Judith, what are your thoughts on that?
Look, it depends. Usually in relation to covert activities, it's normally a collection of evidence and preservation process. So that can happen quite quickly as opposed to observation. If it's a preservation of devices and things, that can all usually be done within 24 hours.
Yep.
So certainly not months and years. And observation to me sounds like you're not sure whether the person's done it or not.
Yep.
And that, if that's the case, then that may be a little longer if you've got questions, but you'd be putting other processes into place to try and pick that up, other controls maybe to try and pick that up earlier, if that's the case.
I know this is from an accounting side of things, generally for us, covert is normally days, week or 2. And by then we would have established enough evidence or know enough facts about whether or not money has been, I guess, diverted or stolen. Judith, this one might be best answered for you. Do you need candidates or employees' permission to do a background check?
Yes.
Yep.
You need, in short, you need their written consent.
Yep.
And in order to do an effective search, they have to complete a lot of paperwork, to be frank.
Yep.
So you'll need addresses that you lived at different dates and so on. It's a fairly decent sized form.
Yeah, the police background checks require their signature.
Yes.
To provide that information to the employer. The publicly available information ones you can do. If it's public record, then you can do those. But
and I think probably maybe Stan, you might have some thoughts on this. In relation to stage 1, how can we evaluate pressure risks on suspects? So I guess without tipping them off. So, if we think they've got lifestyle pressures, financial pressures, how do we go about perhaps identifying that, again, I guess covertly?
Sorry, Stan. There's a few, sometimes when you look back at things, the red flags are kind of obvious. Obviously, that's easy to say with my 2020 vision in hindsight, but usually there are certain things that we would look for. For example, people who just don't take leave. Yep. And there are people who do not like to take leave, so they're not all committing fraud, but certainly people who don't like to take leave. I'm always surprised by how often they have actually talked about these problems with their colleagues quite openly, particularly husbands gambling or other things. So it's really just keeping an eye out.
We've had one in the past where someone was turning up, new car, had done a big renovation. The owner of the business was like, okay, I know how much I pay you per year. I know your significant other is not currently working. They actually then asked some questions because it was a red flag. They were actually then told, oh no, we won lotto. So they dismissed it. Fast forward 2 years, that person went to jail for 10 years for committing a $4.5 million fraud.
Yeah.
Yes.
So,
but I appreciate you can't simply ask people, so how do you pay for that?
Yeah, look,
you do have to be a little bit cautious about how intrusive you are.
Yeah.
But again, that's why good policy will, keep
Yeah.
people focused on what to look for.
Education is important, right? To have
Absolutely.
other staff aware of strange occurrences.
And I think if you are worried, there's always a number of different ways we could come at this. So if there was a suspect that you're worried about, without, I guess, trying to look into lifestyle pressures or things like that, for the risk of tipping them off, perhaps you could do other covert operations through FTech or accounting, and come up from that way.
Yeah, you can look at browsing history or activity like that.
Yep.
Once the evidence is preserved, just to get a feel for what they're doing, such as the gambler that I mentioned earlier.
Yeah, absolutely. All right, well, look, we're just about out of time. So thank you for everyone that's joined us today. And hopefully you've got something out of today's session. If you've got any questions going forward, please feel free to reach out to myself, Stan, or Judith. We're always happy to take a call and here to help. But thank you for joining us.
Thank you.
Thank you.